us is Ruben Carranza, a New York-based lawyer who works with the International Center for Transitional Justice. Ruben is here in town for a brief visit, and we're very lucky to have him with us at this moment for a brief interview. Welcome to Rappler Talk, Ruben.
And I'm happy to be here.
It's been a long time. And first, we're going to talk to you about holding Duterte accountable in the International Criminal Court. But before that, the most pressing and hot issue of the day is the revocation of Sonny Trillanes' amnesty. Since you were Defense Assistant Secretary in the Philippines in 1998, you're very familiar with the process. So what happened here? Is there a model, a similar experience that has happened that is similar to what Duterte has done?
No, first of all, when I was at the Department of National Defense, I did pass through my desk amnesty applications. I saw some amnesty applications of names that are familiar to Filipinos involved in previous coup attempts. But I never saw any revocation of these amnesties, and I think that's because any step that leads to the revocation of an amnesty faces a heavy burden of requirements to be met, and you can't just issue a proclamation that not only revokes somebody's amnesty but orders him imprisoned. There are so many constitutional violations of due process there. I can't even enumerate them. But the point is that amnesties are granted precisely to end a conflict, precisely to resolve political grievances that may have led to conflict, and that's why you don't revoke amnesties, precisely because that you want to avoid conflict again.
So can you help us make sense of what has just happened here in the Philippines? The President issued a proclamation revoking the amnesty based on two grounds. One, there are no records of Trillanes' amnesty application. And number two, he did not fulfill some conditions. As you said earlier, maybe you can help us make sense of this.
I like you said, I worked at the Department of Defense. Yes. I worked with Armed Forces personnel. I worked with J1, that's the personnel command of the Armed Forces, and they're meticulous about record keeping. It's impossible for the Armed Forces of the Philippines not to have a copy of a document that presumably would have several copies of. Nobody, even back then, would have only one copy of a very important document that says, I'm applying for amnesty. But more importantly, amnesties in the Philippines, in the Constitution, require not just a proclamation by the President, but concurrence by Congress. And so when Congress concurs in an amnesty, it's two branches of the government that's saying, we're erasing the acts committed by these persons who are granted amnesty, and they will not be charged, they will not be investigated, they will not be imprisoned. Apparently, in this proclamation, the resolution to which Congress concurred in says that this particular amnesty proclamation requires an admission of guilt so that it can be given due course. Now, I have issues about that additional requirement because an amnesty should have no conditions, unlike a pardon, which can be conditional. That's what former President Estrada received. That's what the actor Robin Padilla received, conditional pardons. In this case, there should be no conditions on amnesties. But in any event, even that language of an admission of guilt for it to be given due course actually serves Senator Trillanes, because his amnesty application was obviously given due course. He won't be in the Senate now if it wasn't. And so that means he fulfilled that requirement that shouldn't have been there in the first place.
So this proclamation issued by Duterte is clearly, can we say, illegal, unconstitutional?
It's not only is it unconstitutional, but it obviously discriminates against a person for his political beliefs and violates international human rights law as well. It obviously singles him out. Why would you issue a proclamation that reviews the amnesty application of one person, given that there have been thousands, perhaps even tens of thousands of people who have applied for amnesties in the Philippines? And when you expand that notion of a president reviewing amnesties, what would stop a president from reviewing, for example, tax amnesties? People who don't pay their taxes get amnesties.
Yes.
So what would stop him from reviewing a businessman's tax records and say, he shouldn't have been given a tax amnesty or he shouldn't have been qualified for that?
And today, Rappler has a very interesting story on the Armed Forces Chief of Staff, General Galvez, who was also given amnesty for participating in the most fatal coup attempt to hit the Aquino government in 1989.
Which is among the amnesties that I had to review. Not his in particular,
yes, but the entire group.
Involving that group, yes.
Anyway, that's having talked about it because it's so interesting and maybe illogical. Let's go to the also long-term issue of holding Duterte accountable before the International Criminal Court. But first, Ruben, you work with this International Center for Transitional Justice. Just maybe enlighten us on what your work consists of and what is transitional justice.
Well, I work in countries that are emerging from armed conflict or emerging from authoritarian rule. And in these countries, they may need to figure out approaches to addressing human rights violations or humanitarian law violations committed during a conflict or during dictatorships. Now, in most of these countries, there would have been many violations, and it would be difficult to resort only to regular courts to find justice. So we help them find approaches that aren't necessarily only through courts. So truth commissions, we help them set up truth commissions. I head our work that sets up reparations programs for victims of human rights violations. So some of the work I do in the Philippines, for instance, was to help the board that gave reparations to victims of the Marcos dictatorship. So I work in post-conflict countries, post-dictatorship countries, but also now we find ourselves working in ongoing conflict countries as well. Syria, South Sudan. I just came back from South Sudan 2 months ago. Transitional justice incorporates these different justice mechanisms that I mentioned: courts and prosecutions, truth commissions, reparations programs, and potentially reforms of institutions that would have been the institutions that commit human rights violations.
Okay. But in the Philippines right now, there is an ongoing campaign against suspected drug users. Is there a role here for transitional justice mechanisms now that this is happening, or should we wait until after a new government steps in?
In our work, we've found that it's important to prepare for a transition. And by prepare for a transition, I mean prepare so that justice and accountability can be pursued if and when a transition happens. Now, it's important because there is no one who can say when a transition might take place and what happens when a transition does happen. It can be very sudden. A head of state might die, or he might lose an election and be forced to depart. That's what happened in Gambia recently, and a new president took over. Or just as in South Africa, Jacob Zuma was forced to resign and a transition took effect. Okay. So what we do is anticipate and document human rights violations that are committed. And in the Philippines, this so-called war on drugs is a conflict. It may not necessarily be a two-sided conflict. Only one side is killing the other. But it's important to anticipate, and I think many human rights groups here have been doing exactly that, documenting violations, identifying both the evidence that might be needed to prosecute those responsible, identifying the needs of victims because they may need reparations, and even setting up the possibility of a truth commission in the future to look at how this happened and how this tragedy of thousands being killed could have happened in a country that already emerged from dictatorship.
So, Ruben, how about, are you also working with countries that are trying to go after deposed dictators or leaders who are facing cases before the ICC?
Yes, and as well as others who aren't. Okay. There are many countries that are either not parties to the ICC or don't have ICC cases. So we work in those countries. There are also countries where dictators are in exile, and we help the countries and the people there try to pursue accountability. And in these situations, the role of the ICC is important, not so much because these cases should go to the ICC, but because the ICC serves as a last resort The ICC serves as a place where if you cannot find justice in your own country, or if it's impossible to even begin to find justice because you face risks, there's always the possibility that the ICC will step in.
So now, in the Philippines, as you know, Duterte has withdrawn from the Philippines membership in the ICC, but that doesn't stop the prosecutor of the ICC from doing its initial probe or preliminary examination.
Right. Right now, the Office of the Prosecutor of the ICC has announced that she has opened a preliminary examination, which is the first stage of a very long process of pursuing justice at the ICC. But I think it's important because the prosecutor does not simply open cases on the basis of anyone filing a complaint. It's not the same as courts in the Philippines, for instance, where if you file a complaint with a fiscal or the prosecutor or a civil complaint with a judge, with a court, that you know that at some point in the future it will be heard. In the ICC, it doesn't work that way. So a preliminary examination is at the initial stage of a potentially long process, and even within that preliminary examination stage, there are 4 phases. The first phase is basically the prosecutor decides whether this complaint or communication, it's called the communication, whether it's frivolous, whether it's actually irrelevant to the function of the ICC. Second is it determines whether they have jurisdiction in terms of time or in terms of the country involved. And in this case, it's obvious they have jurisdiction in terms of when these killings happened, where these killings happened. The third is admissibility, whether this case, in fact, should go to the ICC because there are issues such as complementarity, it's called, to determine whether, in fact, these complaints can be heard or can be justly heard in the country where the crimes took place. And then the last phase is really the prosecutor answering the question, is it in the interest of justice not to proceed? And I have to be careful saying that. The interest of justice question isn't whether it's in the interest of justice to proceed with the investigation, but whether it's in the interest of justice not to investigate. And it's very seldom that you may have a reason not to investigate, but there have been cases where peace talks are happening, for instance. A prosecutor would say, maybe I shouldn't step in yet because I might jeopardize peace negotiations. So that's where the Philippines is at right now in this. The withdrawal does not affect how this case moves forward.
So you mentioned this important principle of complementarity because there's a lot of discussion here that the ICC the ICC will not come in if the local courts are addressing this war on drugs.
That's not exactly how complementarity works. Complementarity isn't about exhausting all available remedies locally. It's not about all 20,000 families whose members were killed filing cases here before they can go to the ICC. It's whether in the country where the crimes took place, essentially whether the crimes for which the ICC has jurisdiction can be heard in these countries, can be prosecuted seriously and credibly in these countries. So there is a test of seriousness and credibility. It doesn't mean that you have to file a case first before you can go to the ICC. It simply means that the prosecutor will examine whether there are cases that have been filed that, looking at the circumstances in which they are pending, they will lead to justice for the crimes that were committed that could have been tried at the ICC.
Recently, there were cases of acquittals. I think two recent cases of acquittals of heads of state in the ICC, right? And one is because the one reason given was that that process was politically tainted, or the evidence was politically tainted.
I think you're referring to 2 cases. One involves the president of Kenya, Kenyatta, and his vice president, Ruto. And then the other case involves the former vice president of the Democratic Republic of the Congo, Jean-Pierre Bemba. In Kenyatta's case, the prosecutor withdrew the charges she filed because she felt that there was insufficient evidence to proceed. Part of the reason there was insufficient evidence to proceed was And this we know because we have an office in Kenya and we work with Kenyan human rights activists. There was a significant amount of intimidation, even violence, committed against witnesses who would have testified against the person's charge, against Kenyatta, because he's president of that country. He has all the power to intimidate and instill fear. In the other case, Jean-Pierre Bemba he was acquitted on appeal on technical issues around whether certain defenses he raised were considered by the trial court that convicted him. I have done work in that country, Central African Republic, and that's a sad outcome where what the kind of justice that people were waiting for can't happen anymore to the ICC because of that outcome. One thing to say about these acquittals is that it also shows that there is due process, no matter how bad we feel about the outcomes, that there is due process at the ICC, that whether you're a president or a general, a warlord or a combatant, that persons who are accused at the ICC, in fact, can expect due process.
What lessons can the human rights groups here in the Philippines or other civil society groups learn from this, acquittals? How can they fortify maybe their cases or their preparation for a case against Duterte?
Well, I think when activists and human rights lawyers, whether in the Philippines or elsewhere, prepare for accountability, they should prepare for accountability as if they were preparing not just for the ICC, but for any opportunities that arise that will help them pursue accountability. It could be a local court. You might have a transition in which a new government decides it can actually prosecute war crimes, or in this case, crimes against humanity, extrajudicial killings committed in the country. They can prepare for a UN Commission of Inquiry because that's possible. In Myanmar, for instance, in the Rohingya case, the UN organized several commissions of inquiry that while they could not go into Myanmar, they were not allowed to visit the Rohingyas, they prepared for that and documentation was assembled. And now, just yesterday, the pre-trial chamber of the ICC in fact said that the ICC prosecutor can proceed to conduct a preliminary examination of the Rohingya case in Myanmar. So documentation is important. Witness protection is also important, as I mentioned in the Kenya case. And witness protection obviously requires more than just a government program, especially here where it's the government that stands accused of extrajudicial killings. There are witness protection processes at the ICC, but they get triggered only at a certain stage of the investigation, not at this point of preliminary examination. There are also countries that might offer witness protection before that process of protection through the ICC takes place. And then finally, I think what's important is to ensure that families of victims, witnesses to the extrajudicial killings, receive the kind of support that they need economically, socially, especially given that this is going to be a long process. This is not something that will happen overnight or in the next few months. Although hopefully, because this examination has been pending for some time, the prosecutor will act on it, and if it happens that she decides to open a preliminary investigation, this is when now the hard work of human rights activists and lawyers will be needed.
In Kenya, how come there was no support for witness protection from the ICC or from other groups?
There was witness protection. In fact, this is the reason why some Kenyans were also charged with tampering with evidence. In the same way in Bemba, in that Bemba case, there were charges and convictions for tampering with evidence. The ICC faces many of the same problems that courts elsewhere have, that witnesses are intimidated, witnesses are frightened. But that's also partly because in Kenya especially, they politicized the case. That's why there were demands for Kenya to withdraw from the ICC, although it did not reach that point where they actually filed a notice of withdrawal similar to what has been filed here.
In the Philippines.
Yeah.
So currently, the Philippines, there's only one Filipino lawyer accredited with the ICC, and that's the spokesperson of the president.
My classmate, Harry Roque, yes.
And you're good friends
Yes.
still?
I hope so.
So, can this be corrected in case, the case prospers in the ICC?
There's a difference between the only Filipino lawyer accredited at the ICC versus lawyers accredited at the ICC. There are several. The ICC regularly appoints lawyers from this list of accredited lawyers to the ICC if I wanted to, or if someone I know wanted to. The requirements are 10 years of practice in a country, in the bar of your country, expertise in international criminal law or international human rights law, and it's not rare. It's not. There are many lawyers in the Philippines as well who can, in fact, apply for accreditation at the ICC, and they can. I think what's important is to not present this as if only one person can ever show up in court and defend somebody. I think it's important for us to be more familiar with the ICC as a court and to understand that there's a procedure
So
involved.
Ruben, you qualify. You've had more than 10 years of practice. And other lawyers too in the Philippines. And as you know now, there's an ongoing case with the Philippine Supreme Court questioning the unilateral withdrawal of Duterte, and that Senate should have concurred in the withdrawal. Is that your understanding also of this, of Duterte's move as being unconstitutional?
Yes, it's unconstitutional, and not only because he did not obtain the concurrence of the Senate. In the withdrawal. It's unconstitutional because, unfortunately for him and for whoever in his legal team drafted it, they actually talked about the reasons they were withdrawing, and these are not only wrong legally, but also very absurd. I recall that his legal advisor said that the Philippine ratification to the ICC treaty was their favorite legal doctrine now is the doctrine of things being void from the beginning, void ab initio, and that it was void ab initio because supposedly they were not told that complementarity will be breached in this case. Now, there are multiple fallacies in that argument, but maybe just one important fallacy is the fact that the Philippines ratified the ICC treaty in 2002, if I'm not mistaken, signed on to the ICC treaty in 2002 and ratified it only 10 years later. So it's impossible for you to have not thought about this for 10 years or to only think about it 8 more years later in 2018, 2017 now. The withdrawal only takes effect in March 2019, a year from the notice of deposit, which is what they did at the UN. There have been countries, in fact, that filed notices of withdrawal and eventually withdrew their withdrawals. And I think it's an important lesson that has been brought up in this case before the Supreme Court by the senators who challenged the withdrawal, as well as the ICC coalition that challenged it. South Africa is the example where clearly the South Africa High Court, its Supreme Court, said that if ratification of the ICC treaty requires an act of parliament, the concurrence of parliament, then withdrawing from it requires the concurrence of parliament as well. So they were forced to withdraw. They had filed a bill in the Parliament of South Africa to have a law that essentially validates their withdrawal. They also stopped the proceedings on that law. I should also mention another country that, in fact,
apart from South Africa,
Gambia announced that it would withdraw. It had never, as far as I know, submitted a notice of withdrawal, but the former president of Gambia was ousted after he was defeated in an election that he tried to cheat in. A new president was elected. Last year, this new president announced that Gambia was not going to proceed with its withdrawal. Kenya was going to withdraw. There was enough opposition in parliament against it that they did not proceed. So only one country has ever withdrawn.
That's Burundi.
Burundi, and this is the country that's now ruled by a president who has killed more than 400 people, displaced more than 30,000, arrested, tortured, and detained hundreds of his opponents, and now calls himself something like the everlasting president of Burundi. So that's the kind of company that the president of the Philippines keeps right now.
That's a very sad commentary on the state of the Philippines, rule of law in the Philippines, that we are in the company of Burundi. Is there any high note or positive note you can tell our audience or about this case? We're trying to pursue. Civil society groups are trying to pursue with the ICC.
When the prosecutor at the ICC opened the preliminary examination into the Philippines and the extrajudicial killings here, she opened it alongside an examination of Venezuela. After that, just a few months later, if I'm not mistaken, an examination into Israel involving its conduct in Gaza. And then, like I said, she opened an examination into Myanmar and the Rohingya, which has now proceeded. So you can see that there is some determination by the prosecutor of what cases she should look at. And I'm glad that she's looking at a wide range of cases geographically as well. She even has continued to examine British troops and their conduct in Iraq, in the south, in Basra. Because it tells us that she's trying to correct whatever impressions there have been that she's been focusing, or that the ICC has been focusing on Africa. She's also, I think, trying to deploy the resources of the prosecutor's office in such a way that she can proceed with these cases. And I think what's important for us here is, while we shouldn't raise our expectations and we shouldn't necessarily expect that the ICC will suddenly open an investigation, proceed to trial. That will take a long time. It's very likely that the Philippine government will not cooperate with the ICC, even if it's legally bound to cooperate. But I think there are going to be political as well as very personal repercussions on the people who might be subjected to charges at the ICC. Remember, the prosecutor, even before she opened the examination, issued a press statement warning not just one person in the Philippine government, but she warned high officials of the Philippine government that have been inciting and inducing the commission of extrajudicial killings against Filipinos. So she's not thinking of just one man or one woman, but several persons. And these persons have families. These persons have families and themselves. They love to travel. They love to go on trips to the Middle East, hundreds of them. These are, Jordan, for example, is a party to the ICC treaty. These are situations that have repercussions, travel, assets abroad, that it might matter that cases are opened even if the ICC case itself doesn't proceed to trial. And even for certain countries that are not party to the ICC, for example, the United States, the US government does take the effort to, of course, promoting its own agenda, but nonetheless does take the effort to examine corruption and human rights violations committed by foreign leaders. It has, for example, something called the Global Magnitsky Act. It's a long story,
it's
but
the Russian.
that's the Magnitsky Act.
Okay.
That applies to Russians.
Russia.
But a separate law was filed called the Global Magnitsky Act, similar to that, that allows the State Department to identify foreign leaders suspected of corruption or charged, not formally even, but suspected of committing human rights violations, allowing the US government to restrict visa issuances to these persons and their families and to freeze their assets abroad. They've done this now for, say, the leaders, the president of Nicaragua and his family, certain other people in Syria and their families. So very selective, but nonetheless something that should be in the minds of Filipinos as well, especially those who live in the United States.
On that note, I mean, it's really compelling that political acts or acts of leaders have real consequences. And as you said, in a wide range of issues that they can be affected personally and as well as their families. So on that good note, on a positive note for the bad people, we thank
Well,
you.
there are bad precedents and there are also good precedents with a
Okay.
C
Okay.
on how accountability can be pursued.
Okay, we can talk about that at another time. So thank you, Ruben, and thank you very much to our viewers and our listeners. And we will keep talking about this issue of holding leaders accountable. Thank you and good day.